Welcome to the Excellence in Training Academy, where trainers come to grow at excellencein trainingacademy.com. I'm very pleased to have back with us Kevin Davis. Kevin retired in 2021 from a career spanning 39 years in law enforcement. Kevin's experience includes corrections and patrol deputy, urban officer assigned to patrol, street narcotics, full-time training officer, SWAT operator, team leader, and lead instructor, and detective assigned to body-worn camera program. Kevin is an active expert witness defending officers throughout the U.S. and is the author of Use of Force Investigations, a Manual for Law Enforcement. So, Kevin, welcome back to the Excellence in Training Academy.
Well, thank you, Brian. I appreciate you having me. A pleasure as always. And may I say, it was nice to be able to spend some time with you in St. Louis and have a little conversation there about different things. So it is always a pleasure.
And likewise. And speaking of St. Louis, at the ILETA conference this year, you did a presentation called Officer Charged, Legal Threats to Officers and How to Prepare. And in your brief course description, it says officers are being politically prosecuted for alleged crimes based on perfectly legal use of force incidents. Law enforcement officers need to know the law, case law, how video evidence is being used against them, how to combat botched investigations, and strategies to report, articulate, defend, and win in a lawful use of force incident. And so I followed up afterwards to see if you would be willing to have a conversation, because I think this is such a critical area and an area that I think a lot of officers still really don't know a lot about or enough about. So where do we start this conversation? What are some of the key elements that trainers need to make sure that their officers are aware of in order to prepare them for these politically charged incidents?
Well, to begin with, there was a period of time, and this goes back a little bit further than people realize, unfortunately, and that's that. When I wrote the first edition of the book, it was in 2012, and I wrote in the book that we were coming to the time when the prosecutors, for political reasons, would rather charge an officer and make him prove their innocence than vindicate him through a professional investigation. And unfortunately, I didn't realize how bad it would truly get. And we are certainly at a time that I never envisioned, even when I wrote that statement. There was a period of time when, in terms of investigations and especially in officer-involved shooting investigations, but I'll talk more broadly about use of force investigations, and that's that, there was a point in time where the goal was to ascertain the facts, an investigation, develop the totality of the circumstances, take a dive into the human factors involved and apply them to the officers involved in the shooting, develop a timeline, and create demonstrative exhibits, in terms of these investigations. But unfortunately, we've come to the time when, as I pointed out in my presentation, that we're now ignoring the facts. Facts don't matter. We're changing the legal standard, and I'll talk more about that in a couple of cases I had in Virginia. We are now full-blown conflating use of force legal investigations with what we call tactical critiques, or examining the tactics and this whole notion of officer-created jeopardy. We don't want to, matter of fact, we suppress the totality of the circumstances. We deny the human factors are involved. We rush these things into indictment, and we push them into court, and that's where we're at. And I, prior to the conference, had been very busy defending officers and talked about several cases, one of which was recently wrapped up prior to the conference in Spotsylvania, Virginia, where a deputy was charged with felonious wounding, or a Virginia equivalent of say a felonious assault, in the shooting of a subject. He was a known mentally ill person who was under the influence of PCP, chronic PCP user, and he had called 911 and said that he had a gun and he was going to shoot his brother. And so that was the background of that case. But that wrapped up prior to the conference, so I used that and interwove that case throughout my presentation. But in truth, Brian, we are not just talking about officer involved shootings. We are also talking about all uses of force, because I had a couple cases last year in Columbus, Ohio, and just to put a background to these were based out of the 2020 George Floyd riots in Columbus. And the city of Columbus, if you can believe this, spent $800,000 investigating police actions during those riots, and it resulted in 3 misdemeanor indictments. One officer went to trial and was acquitted. And then the 2 cases I worked on, the special prosecutor, after I submitted the report, dropped the charges. But if you can imagine, and this was a pepper spraying, and it wasn't even, spraying somebody until they dripped or dropped. It was just spraying at them to get them to drive them away from the area during the riots. And yet these officers were charged with misdemeanor violation of civil rights, interference with civil rights, and misdemeanor assault. So, unfortunately, it's not just for officers nowadays. It's not just the officer involved shooting. It's every use of force that an officer has.
And it seems to me when it comes to investigations that there's kind of 2 elements here. One is the need to have investigators, people that are investigating use of force, and especially officer-involved shootings, properly trained in human factors and all these elements. And through your training and your book and the work of force science and people like Lance LaRusso and Eric Daigle and others, we seem to have more people trained in that, although not enough. But is the other piece that you're now seeing that in some cases the prosecutors, for political reasons, are not even allowing the investigation to be done before they're laying charges against the officer. So the investigation in the mind of the district attorney is irrelevant. They're just going to lay the charge and then move forward. Is that something that you're seeing?
Oh, yeah. And an interesting aspect of this Spotsylvania, Virginia case, and by the way, I'll cut to the chase that the deputy was acquitted. Oh, actually, the charges were dismissed after the prosecutor rested in what they call a motion to strike in Virginia. So to cut to the chase, the deputy, the charges were dismissed. But in that case, you had a new prosecutor in front of the grand jury. And there's some interesting side notes there. Some allegations were made because the prosecutor quit right after this case was indicted, or let's just say the case was settled in civil court. Mysteriously, the prosecutor resigned. But be that as it may, we had the grand jury testimony, which we were given. Normally, never get that. But we had gotten it. It was clear in the grand jury room that the prosecutor never introduced the legal standards on use of force in the state of Virginia. Never talked about when an officer could lawfully use deadly force. Only talked about here we believe this case is excessive, and these are a couple of charges that you could consider. So under those types of circumstances, it was obvious that the deputy was going to be indicted, and that's exactly what happened. So you're absolutely right. The politics of these things. And we have, as you're more than familiar with, in the Tulsa, Oklahoma case of Betty Shelby, the detective who was a very experienced detective. I can't recall his name right now, but I have it in my notes and used that case as an example in my presentation. But he wasn't even done with his investigation before Betty Shelby was indicted. And he actually went in front of the press and said this has never happened before to him. So it was kind of interesting, But you're absolutely right.
And I would encourage people to go back and listen to the interview with Betty Shelby, where she talks about everything that she went through following that shooting, and was ultimately exonerated, but not till after an awful lot of stress and challenge and heartache and threats and a lot of other things that she went through. So one of the things I see, or one of the concerns I have, is that some officers just assume that everything will be all right, that it'll be properly investigated somehow by competent investigators, and that the everything that the union or the FOP or whoever will look after them, as opposed to them understanding some of the critical issues and making sure that they're looking out for themselves. What are some of the things that they need to be aware of so that they're going into this post-incident investigation with a clear understanding of some of the critical issues, as opposed to just perhaps a false naivety that somebody else is going to do the right thing and they're going to be okay?
Well, and you're exactly right when you talked about the FOP, or the police association. What officers need to know, and what they can do, and what trainers need to advocate, is that you get some type of legal defense plan. Vitally important nowadays. In the Spotsylvania case that I talked about, that defense ran somewhere around $800,000. In another shooting case I worked in Bristol, Virginia last year, that defense ran $900,000. So we're talking just short of $1 million. And in order for both those cases to transpire, or to for an adequate defense, the defense team, the attorneys, had to hire experts such as myself, and it doesn't come cheap, Brian. It's a lot of work, and it takes a long time to delve into these things pretty deeply. But when you start talking about advanced video work like 3D animations that they used in Bristol, Virginia, that is really expensive. In other words, they took existing surveillance and body-worn camera video and incorporated it into 3D laser mapping, and came up with an animation that not only showed the shooting from the officer's perspective, but also from the driver's perspective and from over top. Because the question in the Bristol, Virginia case, which was an active shooter case, in that case, you had a subject under the influence of massive amounts of methamphetamine that had a stolen Glock 17. He was parked out in a parking lot at a motel where he had been texting his girlfriend, who was in one of the motel rooms. He didn't know which one, but he had threatened to shoot the place up, and then fired 5 shots in the air from outside of his car. So it was put out as an active shooter. So they confront this guy, and he refuses to get out of the car because he knows he's got the stolen Glock underneath his seat, but he's also got these shell casings on his lap, and he's going to be discovered. He had active felony warrant as well. But in that case, the high-performance Mustang that he was driving, he drove towards the officer, who fired at him with the AR-15 and killed him. But in that case, advanced work, very, very expensive. So trainers should advocate that their officers get some type of legal defense plan. If you, and my union president, my former department, made the wise decision several years ago to purchase FOP legal defense plan coverage for every single officer that was working. And in the case that, we'll talk about, I'm sure, in Akron, that is, he had 8 different attorneys, as well as experts and everything else. So if that had gone to trial, that would have been phenomenally expensive, But so get legal coverage. That's the first one. If you don't have it, you can join an associate lodge of the FOP, from what I understand, and purchase the coverage. Or there are some other plans out there, but it's incumbent upon officers to have some type of legal defense. That's first and foremost.
And
Number two,
that was one of the other elements that Betty Shelby talked about, the importance of that she had gotten that recommendation early in her career, and it did very well by her. So what would be the next key element that you would want officers to know, or trainers to make sure that they emphasize for their people or educate their people about?
Well, the next thing is to make sure that you get the right attorney, because that makes all the difference in the world. There are some great defense attorneys out there, like the people that worked in Spotsylvania and Bristol, Virginia, and Betty Shelby's case. Phenomenal attorneys. I mean, Lance LaRusso, you talked about earlier down in Atlanta area, some of the work he did, for members of the FOP down there was great. And there's some, Eric Daigle, there are some great attorneys out there. So that's probably number two, to make sure that you just don't have some, defense attorney out in the area, somebody that actually knows police procedures and use of force, et cetera. Now, they can make up for that by hiring experts like myself who can educate even the attorneys about the use of force. I did that in both Bristol and Spotsylvania, Virginia. And, we just had a case in Columbus, Ohio that went to trial where the vice detective charged with murder for the shooting of a prostitute he was trying to arrest who was armed with a knife and had cut him. That went to retrial and he was acquitted. So, it takes a lot of work, but getting the right attorney is number two, obviously. And I would say the other thing is to educate yourself. You cannot be dependent on your agency to educate you about the legal parameters of the use of force, whether it's deadly or non-deadly. And I'll give you an example. In Ohio, we have a case called State of Ohio v. White. That was a shooting case a number of years ago where a patrol officer shot and wounded a motorcyclist by the name of McCloskey, I think his name was. Did not have a gun, but made a drawing motion towards his waistband. And so that case went to the Court of Appeals and then ultimately the Ohio Supreme Court, where it's now law in the state of Ohio. And yet most agencies don't know State v. White. Most agencies don't teach it in basic academy and in service. Most prosecutors don't know State v. White. And the amazing thing is, in a couple cases I've been involved with, the defense attorneys have sent the case law to the prosecutors and to the experts for the prosecutors, and they never took the time to read it. So here's case law that they're prosecuting, an officer on the use of deadly force, for instance, and they haven't even read the case law in Ohio. And one case I worked on in Carroll County, Ohio, where the deputy was charged with felonious assault, the prosecutor admitted that he never read it, and that was certainly the case in Columbus recently because, under oath, the expert witness for the prosecution admitted that he hadn't read it. Well, there were two experts, the first trial and then the retrial. Neither one of them read it, and yet you're prosecuting an officer, and this is the law in Ohio. And so, yes, you got to know the law. And here are some, as a sad thing that indicates the state of law enforcement, the use of force in 2023. And that was Virginia passed more restrictive legal standards in 2019 that went into effect in, I think, March of 2020. Both the shootings that I worked happened after the new state law went into effect. The Attorney General for the Commonwealth of Virginia did not mandate training for all law enforcement officers on the new laws. So there was no training. Number two, neither agency involved, Bristol Police Department or Spotsylvania Sheriff's Office, had any training, gave any training to their people themselves, on the new laws. Now, these are new legal standards that are more restrictive than Graham v. Connor. Number three, neither agency in Virginia incorporated the new legal standards in their policy and procedure. Matter of fact, one of them didn't even refer to Graham, I don't think. It was really antiquated. But fortunately, in Bristol, Virginia, the officer involved, his name was Jonathan Brown, and cut to the chase there, he was acquitted in that motel parking lot shooting. After a jury trial, they were only out for about an hour before they acquitted him. But he had read about it, so he was familiar with the legal standards. And that's just, you come to the point in time when you cannot rely on your agency to give you the proper training on use of force. I know that's sad, but it's simply a fact, especially with smaller agencies.
And smaller agencies being the norm, especially in the U.S., but I think if we look at a lot of places, small agencies are the norm. Training is a peripheral duty. They have an awful lot on their plate. So, what are some of the recommendations you have for those trainers on how they can best keep up to date on those key case law decisions and legal issues? And are there places where they can go to get that information to figure out what they need to be teaching or training their people on? Or do they retain someone like yourself as an expert witness to come in just to educate the trainers about here's some legal issues you need to train your people on? What are some of your recommendations for that?
Well, one of the first recommendations that I would advocate is that the trainer join ILETA, and that is, you know, offers opportunities not only in the attendance at the conference, which you and I would both recommend strongly,
Yeah.
but also to get the journal, because what I try to do, and there are other people that are writing for the journal and the use of force topic area, is I try to give the members a heads up as to what's going on out there, based on my experience and reading the tea leaves, if you will. Because I mean, this is what I do for a living, Brian. Is either teaching, and everything that I do is as a trainer. Even when I'm acting as an expert witness, it's to train the attorneys because they're not familiar. Most of your attorneys have never had an officer involved shooting case before. Now in Columbus, my defense attorneys down there, Mark Collins and Caitlin Stevens, unfortunately, have had a lot of cases. I have 2 more murder cases in Columbus alone that officers have been charged in perfectly good shootings with murder. But ILETA, there are sign up for Science newsletter, sign up for Eric Daigle's newsletter. There's webinars that Daigle has for free that you can link to, and he's a good source. There are also a couple of other outlets out there where there are some former police officers who are attorneys who are offering free newsletters and even the videos, webinars, and everything. So there is stuff out there for trainers and officers both to give themselves some advanced training. I would say to go to your department's legal advisor. But unfortunately, I don't think that most small agencies have legal advisors. They have prosecutors. And once again, my experience with prosecutors defending officers in criminal cases is that the prosecutors don't understand police use of force law. So it's a niche area, certainly, and unfortunately, one that is not being filled. Even in this is what the mystifying thing about this is, Brian, is in this day and age, when the focus of the world is on police use of force, agencies are still not training their people and training their investigators, and it's sad.
Absolutely. And so there's a great challenge to trainers is to do the research, find the information, find ways to get the information to your people on an ongoing basis, because they have to be educated about what the law allows them to do and what policy. And the other piece is, I think a lot of people don't know what their policy is. Is that something that you see as well? Is that some policies are, I mean, they're so thick and so onerous that nobody knows what it actually says in there or understands what it says?
Well, let me give you for instance, another case I worked last year. It was a corrections case, but it has some interesting parallels with law enforcement, because it was a sheriff's office that ran the jail. They did have corrections officers instead of deputies. A lot of sheriff's offices, at least in Ohio, use deputy sheriffs that work corrections, but this one, they were just corrections officers. But this was a CO that was charged with murder. And when I looked at the case and examined, this was down in Scioto County, Ohio, and the policy and procedure from the sheriff's office did not even deal with any of the legal standards on use of force. It had not been revisited. I don't even know. I can't recall. It probably at a minimum of 10 years since anybody looked at this case and updated their policy and procedure. The corrections officer involved never received training on the policy and procedure and never received updated training on suspect control. So he was hired 5 years prior to the incident and never received any training once he was hired. The policy and procedure didn't include references to Tennessee versus Garner or Graham v. Connor, but also there's a new case that it has national implication, which is Kingsley v. Hendrickson, which is a case that applies the Graham standards to corrections. Now, in Ohio, they had always said that a pre-sentenced subject who was in the booking area was covered by Graham v. Connor, but an incarcerated subject who was not convicted, there was some gray area. Well, in the Kingsley case, they applied Graham v. Connor in the Fourth Amendment because they're unsentenced. Otherwise, the Eighth Amendment would apply. But in Kingsley, they applied that. So there was no reference, and by the way, no training in Kingsley by the sheriff's office. And so the prosecution in that case hired an expert, and he was a former, very knowledgeable man who applied Kingsley. But the problem is that the corrections officer had never even been trained in it. So, I mean, here's a case. You take a job like a corrections officer, you better know when you can put your hands on somebody. You better know, the legal standards. That's your responsibility. Same with patrol officers. Gone are the days. I mean, when we're talking about officers being charged with murder, Brian, you cannot rely on your agency to properly train you in the legal standards anymore.
And that's such an important point that everybody needs to take that responsibility themselves. A lot of people say, well, it's the agency's responsibility to train me. Well, the agency's not getting charged with murder. The agency's not looking at going to jail. The agency is probably going to be named in a lawsuit, but they're not looking at losing their job and going to jail and being perhaps spending the rest of their life in prison for something. And I think we see in some cases, we see the agencies just immediately drop the officer or the deputy or the trooper and throw them under the bus to kind of separate themselves from the case. Is that something else that you're seeing? Is we're seeing some agencies that are very quickly wanting to distance themselves from their own people rather than support the people when they've acted lawfully?
Oh, yes. In most cases that I work, once an officer has been charged or indicted, that they're going to be separated. They're going to be put on suspension without pay. And this has some serious ramifications there. Now, there are some agencies in the Spotsylvania, Virginia case, that sheriff made the decision to continue to employ that deputy just in administrative functions until he was, acquitted until the trial. But very few cases are like that. And when you talk about, I was at Lance LaRusso's, force forum in Forsyth, Georgia, a couple of weeks ago now, and Lance brought in 3 Atlanta area officers. They were Atlanta PD, 2 detectives and an officer, and both, the incidents that they were involved with received national media attention. And one of them, Garrett Rolfe, was a young officer. I think he'd been on about 7 years at the time of the incident, but that happened in 2020. I think it was June 2020, and it took 2.5 years before his charges were finally dismissed. And think about it, Brian, not only are you losing your paycheck, but your and insurance and all the other benefits, but you're also losing opportunity to have any type of counseling or whatever. And all three of those officers talked about how stressful that was. To give an idea about, how these things go, you remember Betty Shelby, where she was given about 15 minutes notice that demonstrators were headed to her house. Grab your clothing, grab what you can, and get out of there. 15 minutes. And she even apparently lived in a rural area and even left farm animals or family pets there, because they couldn't take them with them at that time. Well, Garrett Rolfe had to move pretty much every 2 weeks for 2.5 years because of the threats against him, etc. And Rolfe was charged with murder. Once again, that was a activist, a prosecutor running for re-election that used him as a political tool. And Rolfe had to wear an ankle bracelet. He had a 6 p.m. curfew every day. And as part of his bond, the judge said he could not associate with any active duty Atlanta police officers. Well, there's your support system. So you have no opportunity, no access to counseling. The friends that you rely on to support you, you can't talk to. You have to wear an ankle monitor. You're moved around every couple of weeks. And, once again, 2.5 years of that. So, I mean, and I think part of this is the process on some of these incidents has now become the punishment.
Yes. Yeah, that's
unfortunately
a very good way of putting it. It's very sad, but it's reality. So people need to be part of a defense fund. They need to know the law. They need to educate themselves. They need to make sure that they do some research so that they are able to retain a competent attorney who understands some of these human factors and the limitations of video and all the other critical elements. What would be another key thing that officers need to know to educate themselves about, and that trainers need to make sure that they're continually educating their people about? And again, when we talk about this for trainers, it's not a one-off and then one and done. This is there's a need for the relentless, consistent repetition of the message on these incidents. What would be another key element, Kevin?
Well, we did briefly talked about video, but understanding that video was originally sold to law enforcement as a means to vindicate officers, and it does a good job of that. But unfortunately, one of the truisms is a lot of times it takes someone that has some advanced training, or they're not a video analyst, because a video analyst works on the metadata and the zeros and ones behind the video, but somebody that understands force and can articulate what's being shown on video. And that takes a lot of work. But one of the things, hiring somebody that can do that, can break it down. And even the people that can, like video analysts that can do some amazing things, may not know what they're seeing because they don't know. I had a conversation once with Grant Fredericks, who is a masterful, video analyst. And he said, Kevin, he goes, I don't know use of force. And I said, Grant, I don't know video, but I know use of force. So, I mean, there's getting the right people into that, but also understanding that the video is now being weaponized against officers. And I go back to several years ago in my agency, we had an officer-involved shooting that was captured by a number of different body-worn cameras. And I made the argument to my bosses that we needed to get ahead of this. We needed to do a press release, much like we've talked about before with, that crisis communication and Melissa Agnes and that whole expertise area. But you need to get ahead of this stuff, but you have to release a context-driven video. You can't just release the raw video. You have to make your case early on, and that takes some work for the agency, but also for the officer to understand that they need to watch their videos and watch all the videos available as part of their reporting process. Now, I've come to the conclusion that they should watch it before they make a statement. And that has changed for me because I've seen video now being weaponized against officers. In other words, I've seen officers charged with crimes before they ever were allowed to watch video. And the video was used against them when it didn't show what the investigator thought it did show. Not understanding frame rate, for instance, in a case I worked in Pike County, Ohio, 3 corrections officers were charged, deputies working corrections, were charged with, in federal court, with civil rights violations. And what the investigator didn't understand is the frame rate on the video led, he thought it was this continuous thing, not understanding that at 7 frames per second there were gaps in between pictures, if you will, on the video, which unfortunately didn't capture the suspect's movement, which of the deputies he pushed off the wall. Well, that wasn't captured. And once again, the misunderstanding is, as our friend Bill Lewinsky has said, about video doesn't capture resistive tension. If you have your hands on somebody and they're pushing and pulling, tensing up, well, video is not going to capture that. So video is a tool that, if you understand it and you use it properly, you can use it to defend yourself, but understand that it's being weaponized against officers throughout the country.
Now, so you have changed your thoughts on that, and you would advocate now that officers be allowed to watch all the video before they give a statement. Is there a caveat that goes with that? That if I'm the officer and I'm watching the video and I'm going, that's not the way that I remember it, that I need to make sure that I give my statement based on my perception of what was happening, as opposed to try to force my statement to match the video, that in my opinion, that's not what I was perceiving?
No, you're spot on. And that's the reason what I've changed from. What I advocated in the past was that officers make an original statement as to what they saw, they heard, they felt, they perceived, and then watch the videos and make, any additions to their statement based on that. The problem is that I've seen video weaponized in my former city, the city of Akron, Ohio. An ordinance was passed which requires that body-worn camera video footage be released within 7 days of an incident. And in that, they didn't want officers to be able to watch video. Well, the Fraternal Order of Police had negotiated a part of the contract which says that officers shall watch all videos. Now, the Fraternal Order of Police made an agreement that we were waiting until after the initial statement, but people believe that those videos show everything. In other words, their eyes aren't lying. They see something, and if it's bad, it must be illegal, or if it looks bad, it must be illegal. Not the whole notion, a awful or awful but lawful, or lawful but awful, those things that Mike Brady talks about. So I think that you have to be careful, because they're going to put that video out ASAP. Will they even allow the officer to watch the video before they release it? And that's a big one. If you don't have it built into your contract, you may not be allowed to see those videos. And several cases that I've worked, that's exactly what happened. They had charged the officer before they ever allowed him to watch the video. So I've come to the point where these things are being weaponized, and I advocate that officers watch the video with their attorney present, and then, say, this is what I perceived, this is what I heard, this is what I saw, this is what I perceived, but I understand that the video is not in keeping with that.
Is it a reasonable expectation for officers to also understand that it's very likely that their perception will never ever match the video? because the video is never from the officers. I mean, it can't capture what the officer is attending to, what they're looking at, what they're feeling, what they're hearing, what they're perceiving, their training, their emotions, any of those things. So should officers go in assuming that their perception and recollection of the events is likely not going to match the video, and that's okay that they do not match?
Oh, that's hopefully that's they're told that in training. That can be a void of a body worn camera system. When people think that it's as simple as putting a $5 box camera on your chest and you're good to go, and there are so many ripples in this whole system, not the least of which is educating officers that their memory does not function like a video camera. They may not even see something like a suspect movement that's captured on video because their head was turned. I mean, it's so important to train officers the difference between memory and video. In a shooting that I mentioned earlier, where I had to twist arms to get that contextual video released. I got through Freedom of Information request, got the officer statements or got their interviews. And during their interviews, not one officer, not one, had an accurate memory of what actually transpired, which is fascinating. So yes, they need to know that, but it's amazing to watch. And part of that I've shown in a previous ILEADA presentation. Okay, here you watch the video. Now listen to what the officers have to say. It didn't even really come close.
Is it ever possible to have an accurate account of what happened with all the flaws of video, the flaws of human memory and perception and attention, all these other elements? Is there ever really an accurate accounting or depiction of what happened, or is there always going to be some discrepancies and the true accuracy is going to be up there somewhere?
Well, I think that's an interesting question, and one that an expert witness can help, or an expert can help with, in terms of developing. One of the things I do, and hopefully every expert does, is develop totality of the circumstances. And part of that is an understanding of the impact of human factors on what officers perceive and what they remember. And when you have things that aren't jiving, for instance, one of the problems with body-worn cameras are that the camera has a higher level of night vision than the human does. And so you're not going to have an accurate reflection of what the officers saw. And that became true in this recent Akron case, because even though the camera was very poorly, the acuity of the camera was not that great, the officers' human eyes, their eyes saw even less in those low light circumstances. So yes, I mean, but you have to examine, see, body-worn camera video, digital video evidence, regardless of whether it's a surveillance camera or body-worn camera, is only one part of the investigation. It's not actually what happened. And sometimes that officer can have a totally different version of events based on their perceptions on the scene.
No, you've talked about human factors, and I think this is a critical piece that we need to make sure we're educating people about. But it seems to me that the key word in there is human, that these are not cop things. These are human factors. These are factors that influence all human beings in these tense, uncertain, and rapidly evolving events. Is that a key for us to continue to reinforce with our people and to educate the public about, that these are not just cop things, these are human things?
Oh, absolutely. Because what you have, Brian, is, you well know, is that the same factors which affect an officer, like perceptual narrowing, what we used to call tunnel vision and auditory exclusion, we've now are talking about is perceptual narrowing. In other words, an officer, for instance, is focused on a small central vision percentage of their total vision on a threat. They may not see or may not perceive what's out to either side in their peripheral vision. Same thing with hearing. They may not hear warnings shouted by another officer, but these things can also impact witnesses. And sometimes we forget that. Why are witness statements so divergent or so different from what the officers perceived? Well, depending on the level of sympathetic nervous system or fight or flight that the witness is experiencing, they may have, especially if they've never been in a chaotic situation, and most haven't, they're really focused on this thing and may confabulate or fill in gaps in their memory. How many witnesses have we had said, oh, that didn't happen that way? And it turns out, well, wait a second, you were at an angle where you couldn't even see this, so they're testifying or making a statement to something that they could not even have seen based on the circumstances. So we have to understand that the human factors impact everyone, and it can be to different extent. A more experienced officer, one would hope, is one that is able to process these things and has a little bit more control on their SNS response than a rookie. But it depends on where the rookie's life experience is as well. So there's no one way we can say, here, listen, these things may the perceptual narrating or may not. We don't know, but here's what we see based on science.
Excellent. Now, when we were talking about video, you were talking about officers writing the reports and viewing the video beforehand. Talk a little bit about use of force reports and some of the things that you see, either some of the really good things that are in really good reports or some of the flaws or missing elements in use of force reports, because it would seem to me that the reporting of those events is a very important piece of this.
Oh, absolutely right, Brian. And I would even expand that notion out to all use of force incidents now, because gone are the days when you think, and to be perfectly honest, in my history with the Akron Police Department, that oftentimes those civil suits were involving the use of non-deadly force and not deadly force. So that officers have to get out of this mindset. And I told attendees at the conference that, look at Columbus. You cannot write a simple pepper spraying thing like a check the box and that's it, or arrived on scene, sprayed subject, drove away. You can't do that anymore. What you have to do is articulate every use of force. And I would caution officers when we're talking about video and articulation is that on those misdemeanor uses of non-deadly force, make sure that you're watching the video prior to reporting those as well. It is a serious mistake to not properly articulate what you consider to be a minor use of force. So with that in mind, when we get into a, say, an officer involved death, excited delirium, in custody death type situation, to go in and what you can't say is one of those things, and this comes out almost every interview. I feared for my life, so I fired. Well, yes, okay, you feared for your life, but I want to know everything that you experienced, all your perceptions, what you were thinking that led you to believe that you were in fear for your life. And officers, I don't know where this comes from because I've heard it recently a number of times, fearing for my life, that's when I fired. Well, no, you flesh it out, brother. Why? What led you to fear that? What? And it has to be the legal standards is the reasonable perceptions. So you have to make the case as to why your perceptions of fear of death or serious bodily injury were reasonable. And you have to put that out there. And, I would rather have an officer, for instance, get emotional during the interview process. Not that, feign crying, I'm saying, but when you get an officer who you can tell in that interview is reliving the experience, and it kind of, all those that emotional impact comes back, which is an important part of cognitive interviewing, as you well know too. Too many of these interviewers go in there and interrupt and ask questions. Just let the guy or gal tell the story. And I had one officer involved in a shooting one time, and I said, I want to know what you smelled. I want to know everything. And he told me things that nobody had expressed. For instance, that this guy, this officer was over 300 pounds. He was a big guy. That the suspect fought like Hulk Hogan, is how he described it. Picked him up and threw him through a plate glass exit door at a shopping store. And he had never said that to anybody before. So mining that stuff for investigators is important, but officers need to know that they need to put meat on the bones in their interview as to why they felt what they did, because they're making the case to a person that doesn't know the law. That's the jurist, whether it's a grand jury or potentially in a criminal trial. You're making the case to somebody that has no law enforcement experience, maybe has no experience whatsoever with any type of violent encounter, that what they did was reasonable, and that takes work.
And I think it was Paul Taylor and Jamie Borden that both said that these investigations are not about who done it, but about why done it. As part of this, that trainers have gotten, one of the things that I've seen over the years is trainers have gotten, and I don't know what the correct word is, maybe complacent, but we've allowed officers to use short generic statements in the debriefs after scenarios or things. Well, I did it for officer safety. I did it for their safety and mine. I feared for my life. And we just say, okay, good. And we move on, as opposed to saying, okay, so flesh that out, explain that to me, because it seems to me those can go horribly wrong when we get used to just using those generic statements, and now on the stand, somebody's going to get in our face quite aggressively and challenge us on that. Is that part of the problem? Is we need to do a better job of teaching officers the art of articulation in training, both from a verbal articulation and a written reporting standpoint?
Yes. A friend of ours, John Bostain, who used to work for the Federal Law Enforcement Training Center, came up with this notion of don't write conclusions. And officers tend to still say things like the subject resisted arrest, so I did, a knee strike to the common peroneal or something like that. That's not how you want to write. You have to tell the reader, tell the potential jurist what you felt, what you were trained in, that you took your knee to the side outside of his thigh, and don't try to write common peroneal because you'll mess it up, but avoid police jargon and avoid conclusionary statements like he resisted arrest, or, I used reasonable force and took him down, and a takedown, directed him to the ground. Oh, come on, Brian. How did you direct him to the ground? Did you say, there's the ground, sir? Could you kindly go down? That's not how it works. But directed to the ground doesn't convey the resistance felt, experienced, or perceived, and the amount of force necessary to control the person. And that's what you have to do. So much we talk about Betty Shelby. I will relate Garrett Rolfe from Atlanta and what his statement was at the conference recently. He said that he had to fight for his life for 2.5 years. That you need to understand that this is not as simple as checking the box on a use of force report, putting a diagram, a circle around areas that you sprayed or areas that you struck or whatever, and leaving it at that. You have to make the case for why you did what you did. And Jamie and Paul Taylor are spot on It's the why you did. You know, we know what you did. We know the end result. For instance, on an officer involved shooting, is the subject was shot. But the question is why, and that takes certainly more articulation.
What would be one last point that you want to drive home to trainers that they need to make sure that they're educating their officers in regards to these use of force events?
Well, I'm going to say something that was echoed just recently, by the Atlanta officers involved in a couple incidents, use of deadly force as well as non-deadly force in Atlanta, and that's that you need to prepare for this stuff financially as well as legally, and that may require that a new officer delay or put off buying that massive Ram pickup truck worth $100,000 and put some money aside. I called it a war chest, but something so that you can pay the bills for a little while. Now you can't do it for 2.5 years. That's impossible. But that you build a war chest financially as well as through resilience. And I'm going to say that this is that out of the two officers involved in Virginia, one of them has left law enforcement, and the other one is back on the road, back working as a deputy now. One was supported by his agency, and one was not. And the difference is looking at the resilience personally, to build that ability to take a hit and get back up, get back on your feet personally. And this is a big topic nowadays in officer wellness programs and everything else, but also to take care of your family by having some war chest, some funds available that you can continue on so you don't lose your home, you don't lose your cars or whatever in the interim, because the understanding is that these things can take 2.5 years before they go to trial if you're charged.
And that's such a great piece, both those elements. And I would encourage people to go back and listen to the interview or interviews with Nick Dougherty, where he talks about the financial piece, and that we need to be educating people about that at the start of their careers, so that when some of these things happen, then we're not in desperate straits. But the resilience piece is also so critical. Now, is the other element for people to understand that even if you get, so for example, the officer Rolf, where he was not allowed to have any interaction with any active serving Atlanta members, that there are other resources that you can reach out to, organizations that are in service to law enforcement around mental health issues and peer support, that if you don't have it with your own agency, find somebody outside. Don't just leave yourself alone on this island.
I couldn't agree with that more, Brian. And I will tell you something good that I just found out in Georgia at the conference, that the Fraternal Order of Police, in conjunction with the Department of Justice, is developing a wellness program. They are doing a pilot training program for peers coming up, and this for instructors who will be able to teach the program. And hopefully this thing will ripple out into law enforcement. The good thing is that you don't have to be a member, or will not have to be a member, of the Fraternal Order of Police to benefit from the program. And I would recommend that, I can't remember the lady's name offhand, but it's on the Fraternal Order of Police website. They do have wellness section that officers can link to. Her first name is Sherry Martin is her name. And she is a former officer that went back and got training as a counselor. And reach out to Sherry, and there are also some great people out there that would make their services free of charge. In the Akron case, in which our 8 officers were involved in the shooting, were recently no-billed, we were able to bring in from the Fraternal Order of Police State Lodge a trainer to talk to not only the involved officers, also their families. And that's so vitally important. I've seen multiple incidents where the families were just, and it was kind of a funny, sad story when we brought in brought in the trainer for our officers. One of the family members walked in and he goes, "Hey, Kevin," and I go, "Hey," and we had gone to high school together, and I can tell you, looking in his eyes, that his son was involved, and it was just overwhelming for him and his wife. And the multiple cases I've been through over the years about how these things impact your family. So this wellness training and resilience training can be expanded upon. First, we got to get the officers involved, but we definitely got to incorporate the families as well.
Absolutely. And do that proactively, not wait till something bad happens to service the families. We need to get them on board right away. So, Kevin, what's the best way for people to find out more about you, to reach out to you? I know you offer training in addition to your expert witness work. You have your book, and I believe I saw recently a post on LinkedIn that your book is now part of the one of the training programs at FLETC for their use of force investigators training. So I would highly recommend people seek out your book. What's the best way for people to reach out to you or find out more about what the services that you provide?
Well, because of a phone ringing, I tend to rely more on email as a form of contact, and that would be trainer, TRAINER, Kevin Davis, no hyphens or periods. So it's trainer Kevin Davis at gmail.com. That said, I do have a website, which is K as in King, D as in David, or for KD forcetraining.com. So it's KD forcetraining.com. And that'll have a link in there for email as well. But I do work on try to get a blog out at least once a month. You know how that goes. But try to stay on. But this is my forte, and this is my passion, and the good Lord has blessed me with the opportunity to make a difference, and I'm eternally thankful.
And you do a tremendous job with that. And so I would encourage people to check out the website, check out the blog. For those of you that are members of ILEADA, make sure you read Kevin's articles in the ILEADA Journal. For those of you that are not members of ILEADA, make sure you join and read those articles and then attend the conference. And Kevin always presents at the conference as well. So, Kevin, I want to thank you for carving time out of your very, very busy schedule. You have an awful lot going on. I appreciate you making the time for this. But more importantly, I want to thank you for everything that you have done throughout your entire law enforcement career and everything you continue to do through your training, through your education, through your writing, and through the work that you do to help enhance the profession and best serve the heroic men and women that serve in this profession. So for everything that you have done, everything you continue, thank you so much for your commitment, your contributions, your passion, and your service.
Well, thank you, Brian. And to those people out there, especially the trainers out there, I say, may the good Lord bless you with the strength and the will to train your people to win. And for the officers that might be listening, may the good Lord bless you with the strength to train to win.
Excellent. Great advice. And so to the members of the Excellence in Training Academy community, as always, I encourage you to let the information that Kevin shared, and he shared a lot of great information, let that information simmer, percolate overnight. And then be intentional tomorrow. Sit down, write out your greatest takeaways, and write out your action steps. What actions are you going to take to start getting this information out to your people and get it out on an ongoing basis, that consistent, slow drip of this critical information throughout the year after year, throughout people's careers, because they may find themselves fighting for their life after the event as well as in the event. And so to the members of the Excellence in Training Academy community, as always, I thank you for your commitment to excellence both in and through training. Always continue to train hard, train smart, train with passion and purpose, and always be willing to dare to be great.